Other requirements include, the other factors the court will look to will include how much of the actual underlying work has been copied. If it's the entire song, or if it's just a portion of the song, that will weigh into a court's determination of whether that's an illegal copying or not. But these cases have been going on for a long time in the pre-internet context as well.
Very interesting. I'm sure we haven't heard the end on this one. My 18-year-old, who's a college freshman, just had a hardware problem with her computer, so she has to be without it for a week. And she was careful to say that it would interfere with her ability to do schoolwork. But the tears started coming when she talked about the fact she couldn't get access to her music. So it is changing the world that we live in. And I'm sure we haven't begun to sort this one through. And it will be very fascinating to watch how the laws develop and how we balance the fair use and the protection of the copywriter or the intellectual property. Well, welcome, Colombia. We have a question now from Colombia, from Medellín.
Muchas gracias.
Buenos días.
Nuestra pregunta es la siguiente.
Our question is the following. In general, organizations are looking to protect industrial property which they own or they are the principals of. Do they want to protect, do enterprises also want to protect specifically things that have to do with intellectual property, intellectual rights, and how do you achieve this?
Okay. Lowell, you were nodding like you had an initial thought, so we'll go straight to you there. How do they want to achieve this?
Well, yes. In today's world, it's extremely important for companies to protect their intellectual property. In our company, before an employee is hired, they have to sign a proprietary information agreement. And the proprietary information agreement defines what intellectual property is, and in addition, what who owns the intellectual property that's developed during the course of their employment. The employees assign the intellectual property rights to the company in return for the salary that we pay them.
Okay, thank you. We have a question now coming to us from Mexico once again, from Baja California Sur, in beautiful La Paz. I can say that. I've been there. It is gorgeous. What is your question, please?
Buenos días. Mi pregunta es la siguiente.
My question is the following. How can you see the patent in a country like Mexico, where there is very little dissemination of that knowledge, in the sense, in the commercial sense, that university is probably known, but not at university level. How can we actually disseminate that knowledge in order to better understand it among students? And my other question is, are we supposed to understand this exclusively as the set of ideas related to the production, to industrial production?
Okay, we have a question that's out. I'm sorry, go ahead.
You had the question.
Okay, we have a question here that has two parts to it. One is somewhat related, I think, to our very first question. How is it that we can disseminate knowledge about intellectual property? And the question was particularly asking us to take anything into account that might be specific to the Mexican culture and that world. Are there any important strategies, ideas that we might have for being able to create awareness about intellectual property? And I think we're going to have the second part of the question repeated.
Hemos perdido la conexión, no.
Okay, we're going to go ahead and answer the first part of the question for now, and we will see if we can come back to the other part. Peter, do you have any ideas in terms of any of the progress of sort of having laws and regulations and then educating the public about that? You know, it's sort of a dual system here. You have to have the laws, but then you have to have people who respect the laws. How does that go together? Any insights from our experience or any knowledge of the Mexican situation?
That's a very interesting question. There are organizations that that attempt to educate the public on intellectual property rights and assist countries in establishing strong intellectual property rights programs and enforcing those rights. One such organization is the World Intellectual Property Organization, Wipo, which was mentioned a little earlier in this presentation. Wipo very often puts on seminars, public seminars and conferences for the purpose of educating the public on intellectual property rights. Wipo also works with national governments in establishing patent, copyright, trademark programs and establishing programs to enforce those intellectual property rights, as well as disseminate the effects of actually infringing those types of intellectual property rights. So that's one organization that you can turn to for advice on this type of thing.
So I think maybe part of the suggestion is that we need to look towards organizations who have that as part of their mission. I do know that even in the classroom environment, when you get people to kind of understand the reason for intellectual property rights and laws, they usually have a better, compliance. They begin to understand after they have spent time and energy writing something that has some value. They then have some understanding of why it just wouldn't be okay to take that from somebody else. And until you've had that experience, I think it's a little bit hard to relate to it. It's out there. Why not?
Mm-hmm. It's very similar to the first question we had about students plagiarizing works. The same thing applies to businesses sort of plagiarizing another company's intellectual assets. And until the country has a strong enforcement program, there is a huge incentive for other businesses, for unscrupulous businesses, to actually sort of steal or plagiarize another company's intellectual assets.
Excellent point. Excellent point. Well, we have another question here coming from Mexico, Irapuato, Mexico.
Buenos días.
Buenos días.
De Universidad Liceo Cervantino en Irapuato.
From the University Liceo Cervantino in Guanajuato, Mexico, the question is, at the end of when the patents expire, both for design and usefulness and utility, can you review the process and get them reinstated?
Okay. This is a question about what happens when the patent expires. Are you able to recreate it again, or what do you do next? Lowell, do you, or Peter? You're both kind of looking at each other.
Oh, well, I'll be happy to.
Go ahead. Jump in.
To jump in. It's important that during the time the patent is enforceable, that you as an individual or the company is thinking ahead and patenting additional intellectual property that builds a fence around your first key patent, so that when the initial patent expires, you still have a defendable position in the technology area.
Okay.
Yeah, the short answer to that question is no. Once the patent expires, the public can practice that invention, and that's the trade-off. That's the basis behind most patent laws. In exchange for granting this monopoly, this patent, this monopoly to practice an invention, for a limited amount of time, there's a public disclosure. And once that limited amount of time expires, the invention is free to be practiced in the public domain. And as Lowell pointed out, companies need to take strategies to figure out, once their initial patent expires, how are they going to continue to protect that technology. And you do that by building upon the underlying technology and patenting the improvements and patenting applications of that technology.
Excellent. Okay. Buenos Aires in Argentina is back again with a question. We'll be interested in this one.
I'm the coordinator of the property rights for industry. And I have a concrete question. What is the criterion to distinguish, differentiate between the discovery of something that already exists and an invention in order to determine patentability?
Okay. This is an interesting technical question about what really makes something an invention. Peter, you want to kick that off?
I can try. It's a very difficult distinction to make. Laws of nature are not patentable, but applying those laws of nature in a certain way can be patentable subject matter. For example, you can't patent gravity, but you could possibly patent a technique for using gravity to, I don't know, separate cells based on their mass or some other such invention. So the actual distinction between, what's a discovery or a law of nature, something that's already been in the public, and what's new patentable material is a very difficult one to make. One suggestion I have, or one approach that you can take in determining whether something is sort of a discovery, maybe to actually conduct patent searches. It's possible that somebody else has already done this, and in that case, you're not the original inventor. You've sort of discovered a process that someone else has already invented. That's one possible approach, but that doesn't solve the problem of distinguishing between non-patentable subject matter and patentable subject matter. It's a very difficult distinction to make, and usually has to be taken on a case-by-case basis.
Okay, thank you. Well, moving around the globe with our question and answer session, we're back to Mexico. We're back in Sonora, Mexico at the Universidad de Sonora.
Buenos días. Greeting from Sonora University, Mexico. I would like to bring back what Peter was explaining about the importance of protecting or even knowing all these legal aspects of rules, regulations as far as intellectual property, that are not only good to protect those who have already had a patent, but to rescue very valuable capital. I would say it's the most important capital that a country can have because it has a high aggregate value, which is intellectual property. I think that for countries, developing countries like Mexico and many other Latin American countries, I think it would be very important for those that have been, that all those intellectual property be incorporated in the curricula, in the educational curricula, because I think we do have some deficiencies in that area. Each country should develop their own system because, as you already mentioned before, each country has its own laws and regulations, and they have their own property right, intellectual property. So the educational programs should be in accordance to those laws, and I think that was my comment, really, not a question.
Okay. I think that was a call for more intellectual property attorneys throughout the world. We're going to take it that way. Very interesting points, though. Most certainly, the laws are obviously different in different countries, and it's important to be aware of those and to operate in the context of your own national system. And I do know that in the United States, and Peter, you could speak more about this, but the whole area of intellectual property law has been a quickly burgeoning one. Can you give us any, insight about the numbers or the trajectory of growth in that area?
I can try. You're right. The intellectual property system, or at least the patent system in the United States, has been around for a long, long time, almost 200 years. But the trajectory of patent application filings has been almost exponential, especially in the last 4 or 5 years. And if you'll study patent filings over the last 200 years, what you'll notice is there are spikes when there are changes in technology. When America sort of came into the Industrial Revolution, there was a spike in patent application filings, people trying to protect the technology associated with moving into an industrial era from a more agricultural time. There are also spikes when there are significant new technological advances. When the microchip was first invented, there was a spike in patent filings around that time. People building upon the disclosure of the original patents on the microchip and improving it and figuring out applications for it. And whenever there is a surge in technology, there appears to be a surge in patent filings that correspond to that new technology or that new advancement. One comment I'd like to make on that the last comment that was made is that well, it is correct that every country has their own intellectual property laws, and they are somewhat different from country to country. There's been an effort in the last 4 or 5 years to harmonize intellectual property laws internationally, and that's another thing that Wipo has really brought to the forefront and has taken a lead role in these harmonization efforts to make it easier for somebody who has an international business to understand how the intellectual property laws of other countries are going to affect their rights.
It's an extremely important move in a more global economy, necessary for that global economy to continue. Well, thank you very much for your questions. Now we're going to move to the second module of our program. It is a pre-taped interview in which ITC associate Fabiola Franco-Weitzel asked Lowell Burnett to give his insights into what intellectual property rights mean to his high-tech company and how he uses intellectual property rights in the commercialization of technologies.
Hello, I'm Fabiola Franco. We're fortunate to have with us Dr. Lowell Burnett, president of Quantum Magnetics, a company that conducts applications-oriented research and development for the commercialization of products based on its award-winning quadrupole resonance, magnetic resonance, and electromagnetic sensing technologies. He's also a former professor of physics at San Diego State University. Welcome, Dr. Burnett, and thank you for being here today with us.
Well, thank you for inviting me to the program, Fabiola.
Can you briefly explain your company's core technologies?
Yes, our core technology is based on magnetic resonance, which is the basis of magnetic resonance imaging used in hospitals for medical diagnostics. When you think of a magnetic resonance imaging system, what you think of is a large magnet that the patient goes into. We've learned to do magnetic resonance without a magnet, and that's called quadrupole resonance. We use it to scan suitcases, packages, briefcases for the presence of explosives or narcotics or other contraband.
And with today's worldwide events, you must be pretty busy.
We certainly are.
Which is good and it's bad.
Yes, it is.
When you came up with your first commercially viable technologies, did you consider other options than starting your own company? For example, licensing arrangements or joint venture agreements, etc.?
Well, to be honest with you, we started the company with a few ideas, and we didn't have those core technologies when we started the company. But as we developed the technologies, we've developed applications that are outside the security area, our scope of interest. So we're in the process now, in fact, of pursuing licensing agreements with other companies to license those technologies.
Good. What importance do IP rights play in your company?
IP rights are a very important barrier to competition. It makes it more difficult for the competition to jump in and produce very similar products. In addition, it's extremely important to protect your IP rights in the company. And one of the most important ways of doing that is to require that every employee sign a proprietary information agreement before they're hired. A proprietary information agreement spells out what important proprietary information is and specifies that any information that's developed during their term of employment belongs to the company in return for the company paying their salary and benefits.
Right. And in these days, that's pretty much a common procedure.
That's a very common
that
procedure.
type of agreement.
Yes.
Good. Would you be able to operate your business without the protection of IP rights?
It would be much more difficult. I think the answer is probably no.
Okay.
IP rights play an extremely important role in our company.
Survival. How much should a company rely upon its IP rights?
Well, certainly not 100%. Your ability to rely upon IP rights is only as good as your ability to win in the courts and to defend your rights. And so you can be in the right, but you may run out of money before the final determination, and in that case you will lose. So.
Okay. Do you ever find that inventions are prohibitively expensive to patent, and has the IP process ever limited your commercialization of a technology?
No, we've never found that a certain invention is prohibitively expensive to patent. But sometimes you have to make very difficult decisions, what to patent and what not to patent.
Based on a financial situation,
based on
perhaps.
finances and other considerations.
Okay. What determines whether or not you are willing to seek IP protection?
There's actually three options. When you have an idea that could be patented, or when you have an invention to patent, you really have to make a decision between three different options at this point. The first is whether to seek a patent. The second is whether to not seek a patent and keep the invention as a trade secret. The third is to determine whether you want to make the invention public and available to all. So you have three different options, and they have very different outcomes.
Okay.
For example, if you proceed to get a patent on the invention, then a patent doesn't give you the right to produce something for the specified period of time. It gives you the right to keep others from producing it, and that's a very important distinction. The second option, which is to keep the invention as a trade secret, is often preferable. Now, if the invention is something that's down inside the machine somewhere, and a person who walks up to the machine, looks at the machine, can't tell whether the invention is inside or not, it may be preferable to keep this as a trade secret and not disclose it to the world, because if you file a patent, you're disclosing it to the world. If you publish it, you're disclosing it to the world. So the possible downside to option number 2, keeping this as a trade secret, is that someone else may patent it, and then someone else may find out that you're using this invention down inside your machine, and they can prevent you from using it. You'd have to do something else if an outside party patented it. So that's the threat. The third option, to make it public knowledge for everyone, is often a very good option when an invention is on the line, because by publicly disclosing it, you can make sure that no one else can patent the idea, and you can use it freely. But then you have to make sure that it doesn't give an overwhelming edge to some of your competition.
Right, and here among those three options, we also go back to the agreements that you make your employees sign before they even start working for you to help you on this type of issues.
That's
right?
correct. That's
Okay.
exactly right.
Good. How do you monitor and respond to possible IP infringements?
Well, there are two ways, actually. One is to keep a a sharp eye on the marketplace, to go to trade shows and the like, and look for evidence of people infringing on your intellectual property portfolio. That's fairly straightforward, and if you see evidence of infringement, typically you'd have your attorney, your law firm, send a letter to the infringing firm, and then it gets sorted out after that. Civil battles over patent infringement are extremely expensive, and something that certainly as a small firm you want to avoid. There's a second option, however, and it's related to the proprietary information agreements. For example, if a competitor hires away some of your employees and you suspect that the employees have taken proprietary information, then under U.S. law it becomes a criminal matter. And so it's not a civil battle in the courts. In fact, the U.S. has a law, the Economic Espionage Act of 1996, that covers all facets of this. And there are serious penalties for such acts.
And we are talking about serious penalties.
That's correct.
Right. And my last question, what are some of the things that you recommend when managing the IP rights of your products and services?
Well, first and most important is to get every employee to sign a proprietary information agreement that's ironclad and drawn up by a competent intellectual property attorney. The next is to encourage employees, when they have good ideas, to document their ideas and file what we call intellectual property disclosures, or IPDs. These intellectual property disclosures are signed, they're witnessed, and they're date stamped by our intellectual property attorney. So they determine the date at which an invention was conceived, and can be very valuable in court if there's a subsequent infringement suit later on. The third thing that's very important is to make sure that you hold periodic meetings. In our company, we have an intellectual property committee that meets every 2 weeks. And we have periodic meetings. We review the status of our intellectual property, and we determine which inventions we want to move ahead and patent, which inventions we want to keep as trade secrets, and which inventions we want to publish and make public.
Thank you, Dr. Burnett. We appreciate your insights.
Well, thank you very much for having me on the program. I really enjoyed it.
Thank you, Lowell. That was very interesting. And I know that your area of expertise is completely new to me, and I suspect that that is true for many of our viewers. Can you tell us a little bit more about the actual products that you produce?
Yes. Our goal has been to develop new applications of magnetic sensing, magnetic sensors, and apply them to security. For example, we've designed and built an explosives detection scanner for briefcases, airline luggage, that's very, very accurate, very high performance. It's based on the same technology as magnetic resonance imaging, but with some variants. And it's unique because when a suitcase goes through the machine and is scanned, it doesn't require the interpretation of a complex image. It either provides you with a red light or a green light, which even a very low-paid airport screener can interpret. In addition, we've developed a new concealed weapons detection device. Right now, this is in the a portal configuration, so you walk through it. But when you walk through it, it doesn't just go beep. When you walk through it, it takes your picture, a digital picture, stores it in a computer. If you have a concealed weapon on you, it locates the concealed weapon and puts a dot on the location of the concealed weapon on your image. And it doesn't false alarm on keys or glasses or pens or other metal objects.
Well, the obvious follow-up is that since September 11th, I would suspect that that the interest in the kinds of products that you are working on has escalated.
It certainly has.